Bring it together, Julie.
Okay, our next speaker is Joe Shawn, and he's from the Ohio State Crime Lab, and he's going to give an update on the lab.
Good afternoon. I understand you all have been moving along very fairly expeditiously here today. I will do my best not to break that trend.
Thank you.
I do have some information regarding what's been going on over the last year at the State Crime Laboratory, which I hope will be of some help to you. I know you've already heard about the development that will probably have the most impact on you in your day-to-day jobs, that is the case management guidelines, the implementation of the case management guidelines. We'll talk a little bit about that in the pretty bit about it. Recently, it's been 4 or 5 months now, purchased a new automobile, and with the new automobile came the trial subscription to the Sirius radio. And I've gotten hooked going back and forth to work on the old time radio channel. They play the serials from the old radio shows. Doesn't look like anybody here other than me is old enough to remember those. I've enjoyed them. It's The Lone Ranger and Captain Midnight, if you know any of those. Anyway, they always begin. Frequently begin, I guess always is an exaggeration, with when we last left our hero, such and such and such and such and such and such. Well, when I was here last year, when we last left our hero, the State Crime Laboratory, probably things didn't look very good to you. Those of you who were here heard that we had substantial increases in case submissions. We had no increases, in fact, even lost 5 positions in 2011 budget cuts, and no increases in personnel. And then we had the complication of the Melendez versus Diaz court decision, which we'll also talk about a little bit here in just a moment, which requires our laboratory analysts to present the results of their work in a criminal trial personally. They must appear in person to testify under the Confrontation Clause of the United States Constitution. That decision came down from the U.S. Supreme Court in June 2009. Prior to that decision, the practice in North Carolina and pretty much throughout the country had been, in most instances, for forensic scientists to present the results of their analysis by means of an affidavit. We attach an affidavit, incorporate a report reflecting the results of their testing, examination, what have you, and typically that would be introduced into evidence by the prosecutor without further ado and without the requirement that the forensic scientist be personally present to testify. That's no longer the case in North Carolina, and it has had a severe, distinct, significant impact on the operations of the laboratory. Okay, when we last left our hero, okay, things weren't too good. In the budget session that concluded, the legislative session that concluded almost shortly after your last meeting, the General Assembly passed in the budget the following statutory section, saying that the Department of Justice, that's us, shall develop a plan for a Western Regional Laboratory and report on that plan no later than February 1st, 2013, which should include estimated costs, plans, operation, time limit for completion, and other relevant information. Well, that sounded pretty good. Sounded like maybe they were at least inching along towards allocating some funding for a laboratory in Western North Carolina. And that is the real problem for Western North Carolina counties. I don't know if any of you are representative, basically Greensboro West. The problem is we have neither forensic biology, DNA, or toxicology, which are a drug or the analysis of blood for the presence of drugs or alcohol, typically in DWI cases. We don't have that currently, that capability in the Western Region Laboratory. So all cases, DWI cases, DNA cases, the analyst, because of Melendez-Diaz, must travel to court from either Raleigh or Greensboro all the way out to the Western campus. And that's, any of you who've driven even to Asheville lately, 3 hours or so from here, maybe a little more, know that, okay, get up, you drive there 3 hours, you wait, sit in court, finally get called to testify, maybe, find out one way or another, and then turn around and drive 3 hours back. Well, what's happened to your entire workday?
No work.
It's disappeared. And you haven't been, if you were a forensic scientist, in the laboratory doing the analysis of the cases that keep coming in on a recurring basis. So anyway, so yeah, they present this plan. We sure jumped on it. They presented the plan. Very nice facility, 36,000 plus square feet, accommodating 48 scientists and support personnel. Averaged about 651 square feet for a staff member. That's at the low end. We looked at the low end of space, typically in some of the forensic science laboratories, public throughout the country. And we did add in Western North Carolina, provided space for it in this facility, forensic biology and toxicology services to serve the 36 basically western counties at a cost of $16.8 billion, which is certainly not cheap. We understand and appreciate that. In Wake County, if any of you are here from Wake County, one of the high schools recently renovated or presented plans for renovating their athletic facilities, including football stadium, and that was close to $5 billion. So it's 16 guests, but if they consider the nature and the function of the facility. So this was, we were directed to propose this plan for Edneyville, which I guess is a little this way of Asheville, and that's where it was proposed to be located according to the General Assembly. So we look forward with great anticipation to this next session of the General Assembly having presented this plan to see what indeed might happen in terms of a laboratory in Western North Carolina. Lo and behold, in the Capital Appropriations General Fund of Session Law 2013-360, basically the budget, they allocated for Western Crime Laboratory Planning a non-recurring allocation of $1.4+ million. That was a little puzzling to say the least, since we had presented a plan already. We assumed this meant a more developed plan on-site and site planning and so forth, and that's essentially the way we are approaching it. There was no specification in the money report, which is a document basically attached to the budget. No appropriation for any construction. Did reiterate the $1.4 million planning money, and notes that initial planning funds were authorized in Session Law 2012-42, the one we just looked at. Remember, the planned facility will be 36,050 square feet, estimated cost $16.8 million. Exactly the plan we presented. But you'll notice nowhere in there do they say plan will be located at, or the laboratory will be located at Edneyville, Asheville, Morganton, Jackson County, you name it. So we're sort of taking clues from these descriptions if they are indeed referring to the Edneyville site, but frankly we don't know that for sure. We will present again a site-specific plan at Edneyville for this facility. See what happens this spring. Some better news in the budget. Recurring, it was ours and ours as legislators code. Keeps on coming, or it's only one time money. $1.5 million for 19 new toxicology positions to serve the western part of the state. This includes salary up to 224 plus 100,000 in lease funds and scientific supplies. So they have allocated funding for the 19 new toxicologists that we asked for to locate in the western part of the state, but they haven't allocated any place to put them. So, but they did increase our lease allocation, and we assumed, and deduced from that we're going to have to, and we are looking for a lease space, hopefully close to, adjacent to our current facility there in Skyland, which is just outside of Nashville, and where we can accommodate these 19 new toxicologists. That would be a tremendous improvement, and would be a great relief to the criminal justice system, and particularly in western North Carolina. Unfortunately, it's not going to happen tomorrow. Maybe if I come back here next year, I can say everyone's in place. They're just about to finish their training, and pretty soon they'll be ready to start doing these analyses of the DWI cases that the folks in the criminal justice system have to complain about in western North Carolina. In addition, there is some over $1 million to provide the equipment. As you may know, the instrumentation, gas chromatograph, mass spectrometers are not inexpensive instruments, and they would need several of them to accommodate these 19 new folks out there in western North Carolina. In addition, this may be of some interest to you, some of you folks may be interested in this, they allocated $750,000 non-recurring dollars for outsourcing of toxicology cases to private lab service providers, and indicated the priority should be given to cases originating in the western part of the state. And we have proceeded with drafting and have presented to the Department of Administration an RFP, a request for proposal, which means, okay, here's what we need. We need some we need some toxicology cases to be analyzed. How much is it going to cost us? And give us a proposal for that. The kicker in this, of course, is going to be where we started off at the outset of this presentation, Melendez-Diaz versus Massachusetts. Included in these proposals is going to have to be a cost of the analysts coming from wherever the outsourced laboratory may be located. And there are no toxicology outsourcing laboratories in North Carolina, so it's going to be Mississippi or Pennsylvania or some similar place. Included in the proposals will have to be the cost of those analysts coming to district court in Macon County or wherever to testify, and then when they appeal the case to the Superior Court, coming back again. I can tell you that we had some preliminary inquiries regarding how much outsourcing would cost, and those estimates for court appearance were not cheap, upwards of $2,000 and much upwards of $2,000 per case, per appearance in district court. So the General Assembly apparently realized that there may be this issue, and they also indicated that if the Attorney General determines that for one reason or another it's not appropriate to outsource toxicology cases, either to legal or fiscal, and cost too much, concerns involving analyst testimony, those funds that were appropriated, that $750,000, shall be reallocated to increase toxicology analysis capabilities within the state crime laboratory. And you go back, remember the $750,000, well, you start multiplying that by, let's call it $5,000 a case. That's not going to go real far. It may help us in the short run, and perhaps that was the intent, but it's not going to go, unfortunately, go real far. Okay, somebody I understood asked about this earlier. Also in the budget, The North Carolina State Crime Laboratory and the State DNA database are hereby transferred from the State Bureau of Investigation and shall be relocated elsewhere within the Department of Justice as determined by the Attorney General. That includes a relationship that, between the laboratory and the SBI, which began to some extent in 1937 when the Bureau was founded, more so in the 50s and up through, including just prior to the passing of this legislation. That is just administratively represents a significant change in how we're going about things. We have 50, 60 some individuals who are sworn law enforcement officers. If any of you are in that category, you understand all of a sudden what happens if your certifying agency, the folks who hold your badge or hold your papers, suddenly cut out from under you. And we have reached a written memorandum of agreement with the SBI to enable those folks to continue their law enforcement status. They will not serve as law enforcement officers within the crime laboratory. I think this was an inevitable development, and maybe it came along a little sooner and a little more unexpectedly than we had anticipated, but it was an inevitable development. And I think the bottom line, we are in the laboratory, we do forensic science. We did not do law enforcement work. I've said repeatedly, and may have even said it here last year, that based on now my 3 years in the laboratory, observing, talking to, watching, checking up on, if you will, the analysts in the laboratory, I'm fully convinced that each and every one of them is a honest, thorough individual, that they do the they do the analysis in criminal cases, record their results, and then let the chips fall. That's proper, appropriate, and that is the true function of the forensic laboratory. Sort of consistent with the separation of the laboratory from the SBI, the legislature also indicated that we did not no longer hire any sworn personnel to fill vacant positions. That is the way we're proceeding, including with those 19 positions. None of those positions will be sworn positions, at least not none of the new acts positions. We're not advertising for any sworn members positions. The section also indicated is not to be construed as affecting current personnel, so they may keep the job. Basically means we're not required to terminate current personnel as long as they and it would not affect their sworn status as long as they maintain their retention standards, and that's the agreement, memorandum of agreement that the crime laboratory has with the SBI and sworn analysts or analysts who have to be sworn. They continue to meet their sworn status retention standards through the SBI. One very good thing in the budget, funds appropriated to the laboratory shall not be reduced in order to meet any portion of the operating efficiencies reductions set forth in the Act. Many agencies, departments, including the Department of Justice, of which the crime laboratory is a part, were mandated by the General Assembly to cut funds. This section, this is the second year in a row we've had this provision that the Department of Justice, they're required to cut funds, but not to touch us. That's pretty good for us. Of course, you all who work in agencies and so forth know how competitive agencies within an agency may be. May not make us real popular with some of the folks who are taking cuts, but our situation is dire, and as you heard last year here, and I'm certainly glad the General Assembly has recognized that and will not allow the Department of Justice to take any cuts from our operation. And truthfully, it would make sense. We just gave us 19 positions, and the purpose is to help us become current, to have the resources to become current. They're going to give us 19 positions on the one hand, and then allow DOJ to cut on the other hand. It wouldn't make any sense. So this is consistent with the legislative act. I'm required, the crime lab is required through the Attorney General to report on the work of the laboratory. We filed that report on October 1st as the General Assembly required. It is on the General Assembly website. I had it written down, so I can't put my hand on it right this second. If you're interested, on the General Assembly website, the Justice and Public Safety Oversight Committee. So on their link, we have all the information there. That we provided all the information that we were required to do. Any of you who may be interested on an ongoing basis, how many cases, submissions are coming to the laboratory from your respective counties, you can find that information in this report. We were also required to, in conjunction with the School of Government and the DA's conference, to develop a training curriculum for district attorneys. That has not only been developed, it has been completed this past month. And it was, as I understand it, was recorded and put on bid for training purposes for DAs in the future. I believe that was the legislative intent. Some of you may be interested. We're going to have a similar presentation, I believe, in January for the Defense Council, and that's being done through the Indigent Defense Services Group and others. Outsourcing. Remember, the laboratory was given $750,000 to do outsourcing. Outsourcing, by the way, is send it somewhere else to get them to do. The District Attorney's Conference was given $500,000, $500,000 to establish a grant fund to allow them to obtain toxicology analysis from local hospitals. The theory being presumably that the hospital in Asheville, if they do it, well, that's a whole lot closer to the Asheville, Buncombe County Courthouse than Raleigh or Greensboro, and presumably the technician there who took the blood or analyzed the blood in the hospital would be more available to the court system. And we'll see. I had no idea. We had no dog in that fight as an agency. As an observer who's been in the court system a mighty long time, I wonder how happy hospitals are going to be when they start turning around finding their folks sitting in various courtrooms throughout the state on a fairly regular basis for a fairly long time, so it's per day. We'll see. It may work out. And as a practical matter, I think the view was in the General Assembly, in any case, reduced our caseload and our review was better. Other legislation, this sort of consistent with that previous provision. They changed the statute regarding the admissibility of blood analysis or urine analysis for drugs or alcohol, and provided that any analysis done by a hospital laboratory approved by the Department of Health and Human Services would be admissible. That's a substantial change from the previous statute, which limited the admissibility to those agencies which were accredited or scheduled to become accredited. So that's different. Again, that's not something we saw or had a role in. It is a different procedure. And this is what I was alluding to. This is what was stricken. It shall be performed by a laboratory body that requires performance of certain forensic science requirements and is a signatory to the ILAC Corporation for accredited labs. Okay. Well, that's sort of added good news where we last left our heat. We've had a number of positive developments through the year, and I'd just like to touch on those reasonably quickly. You may be aware that 1st of June we became accredited under ISO IEC 17025, a fancy name for international accreditation. These are the highest standards and procedures, protocols applicable to forensic science laboratories. This is a significant achievement, and we're very proud of it. The Attorney General has indicated that he is desirous and has been over the past 3 years of the laboratory acquiring a dual accreditation, that is further ISO 17025 accreditation by another agency, another accredited agency, and we are going forward with those plans. That should occur sometime after the first of the year. We currently are accredited by Forensic Quality Services, which is one of the ILAC signatory agencies in seeking accreditation from ASCLD Lab, which is also a ILAC signatory. Forensic Scientist certification requires, basically you understand what certification is, requires our lab scientists to become certified by an outside agency in one or more of their forensic disciplines. All of our current forensic scientists who are eligible have achieved certification. I said who are eligible. Some of these agencies that bestow, if you will, certification require a certain number of years of experience and other requirements. And we do have some new folks, quite a few, as you'll see in just a moment, new folks who have not yet become eligible. But all of our folks who are current folks who are eligible have achieved certification by an outside agency. Case management guidelines, you've already heard about those. It is another way of trying to address, and we'll talk about a couple more in just a moment, trying to address this large volume of cases with only the same number of folks that we've had for a number of years. I wasn't here for the presentation. I will tell you that the theory behind the case management guidelines is simply sequencing. Processing is a strategy for processing and accepting cases. What we saw in looking at our case queues, if you will, case submission queues, was that there were these cases that you all are familiar with that have a major jurisdiction where you all or whoever brought in 100, 150 items of evidence. Well, if that case gets plugged into the queue, you understand, it's common sense. Everything that comes in after it waits. So what we're doing is saying, bring in a certain number, finish those. If you need more, bring them in, we'll finish those, and so forth, instead of frankly bogging down the entire system and the entire state with your big case, important to you, whatever county it may be. But it certainly is disruptive of the operations of the lab. So not turning away anything, we have initiated a process for handling and managing. That's why we talk case management guidelines. Full-time lab legal counsel. This is one of the very first things I did when I came to the lab 3 years ago, and I continue to insist that the best thing I've done is the most important thing I've done, the most significant thing. We have full-time on-site legal counsel in the laboratory available to lab personnel for any questions legally that might come up. More importantly, available to folks who have inquiries from the criminal justice system, prosecutor, defense counsel, and the like. And Joey Strickland is our legal counsel. Her office happens to be across from mine. I see her on the phone probably 50% of her day. She's on the phone, answering inquiries or responding to inquiries. And I think it's been a tremendous benefit to the criminal justice system simply by providing information. Either, yes, crime laboratory can do this, no, crime laboratory can't do that, but maybe you want to try this, and so forth. She's been available for those consultations, and has, I think, performed just a tremendous service. I have said, I will say here, that had there been a full-time on-site legal counsel in the laboratory for the past 10 years, 10, 15 years, I probably wouldn't be laboratory director because circumstances that brought me to the laboratory would not have occurred. Forensic Science Advisory Board, these are 17 really well-known folks in the forensic science field from throughout the country. They meet quarterly and are on a consistent basis providing their advice and counsel to the laboratory. Lean Six Sigma, I want to take just a second to talk about that. Remember I mentioned a moment ago about us striving to find ways to attack and deal with a large number of cases with the resources we have. Frankly, I'll tell you all, that's the only way I can in good conscience go to the building assembly and say, I need more folks. Because we have done and do as everything we can possibly do with the resources we have. We've made some gains. Made some pretty good gains. But we still don't have to. Lean Six Sigma, it's a process, methodology that was developed by the Toyota and Motorola Roller corporations. Lean, using the lean principles, you remove what's called the unnecessary, don't do stuff you don't need to do, and the Six Sigma concepts improve the necessary, streamline and the process for doing the things that you have to do. And that's where part of the process, part of the thinking behind the case management guidelines. Anyway, we began this project early in the year. In the drug chemistry section between January and May, they increased by 93% the number of cases that they were completing. The drug chemistry, which is our biggest, I call it our biggest seller. That's where we have the greatest volume. Their goal, they set a goal, was 100% increase by the end of the year, which we haven't gotten to yet. So they essentially see their goal in half the time. Forensic biology similarly experienced a 56% reduction in the case processing time during the first 5 months of 2013. Most significantly in the DNA database, and this is where the samples are submitted for placement in the national database, the CODIS system, they increased their overall efficiency by 41%, well in excess of their goal of 25%. And the pending number of samples waiting processing was reduced in convicted offenders by 67% and arrestee samples by 47%. I can tell you that was at the time at the conclusion of the project. They are essentially current now in that particular aspect of the operation, which is great. And we have, as a result, have separated out the database as a separate section from forensic biology, which is the DNA section. Laboratory information management system, most of you are familiar with that. We continue trying to make improvements to that to make it more user-friendly and accessible and beneficial to the folks in the criminal justice system who utilize it. Robotic technology, this is just another way, particularly in forensic biology, of trying to make the most efficient use of the resources we have. The robotic technology means that they will be able to process cases more quickly than previously. DNA quality assurance audits 3 years in a row with no findings. That means they didn't find anything wrong, period. Not a little ding, not a big ding. What happened, found nothing wrong. That's remarkable. To me, that says that when the court system gets something from our folks, particularly the forensic biology, the DNA folks, they can have some reasonable confidence that what they get is 100% accuracy. Continuous posting of vacancies. The vacancies that have been an issue. We'll talk about that in just a moment. The process in the state government, as you may know, vacancy occurs, you've got to send over the posting for that position. People apply, the posting is closed, conduct interviews, make a selection. And in our case, you have to go through investigation, background, polygraph, and so forth. Chances are your first selection for one reason or another, maybe the salary is going to drop out, so you go back and start all over again. With continuous posting, we now have this pool of applicants, so we don't have to go through that laborious process every time in every position. Okay, challenges. Well, they're not much different from last year. 35,000 plus cases came into the laboratory in fiscal 2013, plus 28,000 CODIS and DNA and the rest samples, over 60,000. Melendez-Diaz, we talked about that at the outset. 2,000, this is a minimum, 2,822 hours of analyst time was spent driving to court, waiting in court, testifying, driving back from court to the laboratory. That's 70.55 5-day weeks. That's over a year, well, a year, we got a year and a third of an analyst time to spend basically in all. There's a time in court that is fairly negligible compared to the trial time. Our numbers have not improved. 124, that's what it was last year when I talked to you. Now we do have the 19 coming in. That's a big start. But when you look up at 35,000, you can say, well, it doesn't quite seem like it's enough. It's not. The most significant issue, and this has been the most frustrating for me, is the pay. It is so frustrating. In fiscal 2012, 2013, we had 18 folks. There's about 180 employees, 124 was the analysts, but we had 18 folks leaving the laboratory. Some were retirements, some were other reasons, but 9, fully 50% of those said they're taking a job somewhere else where I can get paid better. And if you have a young parent, mother, father, with children, and as is our case in Wayne County, I don't know everybody from CCDI is here, but we've had several folks go next door. They're living right next door. Okay. And when you go to work, they just go to the next driveway, so that's not a big change. And they're increasing salaries reportedly. Misstated, but reportedly around $20,000 a year more. That's pretty good. How can I tell that person?
I can't.
How can I tell
That
them
did
you
not
can't
go
go?
down today.
You cannot possibly do it. And significantly for that young parent, instead of driving from Raleigh to Aiken County, even Mecklenburg County, or wherever, cool. And tying up a whole day, coming home late because they didn't call them as a witness until 4 o'clock, and coming late, and I got to pay them overtime. But they're coming, but for their perspective, they're coming home late, and that's time taken away from the family. They're working in Wake County at CCDI lab. They get the car, they're going to $10, come back. That's a significantly different situation. So we are losing those people, and it's a revolving door. We've calculated that the cost to the state in terms of lost training and salary and so forth, over $114,000. Well, that's over $1 million we just lost. The state money, tax money, your money, in the fiscal year 2020. Department of Justice did a salary study for our folks and found that compared to Virginia, Georgia, South Carolina, and some of the local in-state laboratories, our salaries were below the average minimum, maximum, and survey total average. I'm assuming that means they were at the bottom in all of those categories. So it is a very frustrating situation that we hire, go through all that lengthy process I talked about, hiring someone, to train them, help them get certified, and all of a sudden somebody says, wow, they're fully trained, very qualified, certified forensic analyst. Here's a job, $20,000 a year more. Well, what are they going to do? Where does that leave us? Starting all over again. And unfortunately, during all that time that we are hiring, training, and so forth, that analyst was not attacking that lead line cases, those 35,000 cases. So, no secret, now you're all the first to hear it. I'll be over there next month. One of our pitches to the General Assembly this year is stop the revolving door and give us some means of retaining the good folks that we have, that we're training and bringing in. Bottom line, that's the bottom line. Bottom line for the year. Some really significant achievements and some help, yes, from the Senate in terms of new positions. Second, and you all and folks in the criminal justice system throughout the state can see remarkable changes over the next 12 months as well. We hope to see some modest improvement, which frankly, at least for the next 12 months, will be the result of the internal efforts that I'm talking about that we've made, as opposed to the help we got from the General Assembly. And 2 years from now, the combination of those two things, the General Assembly and our internal efforts, maybe make some significant changes that will affect that our circumstances have. Okay, probably took too long, but I'm happy to respond to any questions. Couldn't have been, that must be because it's after 4 o'clock. Or is it? Okay, I don't have a plan. Okay, well, thank you all very much for your attention.
Mr. Sternberg has graciously agreed to do a presentation on the gun laws and assistant.
I was asked about 45 minutes ago or so to throw something together. This is what I managed to throw together in that period of time. I'm Al Sternberg. I've worked with the Wake County Sheriff's Office now for over 25 years. I've been the evidence custodian for about 2.5 years. This is not an easy job. I think everybody here has spent even a week in an evidence room should know. I would have to say that of all the crap all that my department has, we've got somewhere on the order of about 19,000 or so items of evidence. Firearms represent probably the single biggest headache to deal with out of everything that is in that place. That includes money, drugs, all the things that people want to steal, and that you want to keep them out of your evidence room and keep people away from those things. But guns they're something else. Yes, the law did change on September the 1st as related to how we may dispose of those firearms. I'm going to be talking about that, and also some of the ways we've been trying to address dealing with guns. As working in a sheriff's office, I would say that roughly 50 to 60% of the firearms that come to us, we get in 50B types of seizures. And when it's not just 1 or 2 guns, we have to get the guy's whole collection, and the bullets, and the mags, and things I don't even know why they grab them, what my guys do. Another 5 to 10% of the guns that are taken are in safekeeper situations where it can hit, in the middle of the night, it made a whole lot of sense, and then in the next morning, I'm trying to reconstruct it. Why do we have all these guns? Okay. I read a report. Hopefully, there's a report that explains why we took these guns from this guy that the SRT guys had to come out and do a forcible mental commitment on him because he was doing all kinds of crazy things. It's lucky he wasn't. It wasn't a suicide by cop type of deal. But anyway, I've got these guns, and then and the officer says, "Well, you know what? Just come in and call us in about a week or so, and you can have your guns back." Well, it's not that simple. Because, as we're going to talk about, I had one of our younger deputies, he brought me a couple guns, and he explained why he took them. So I asked him, okay, did you do any kind of background check on this guy before you told him he could have his guns back? Well, I tell you what, go down the hall. I told him who to go and told him who our analysts are. Go talk to them. I want his CJ Leeds pull up, and I want a criminal history run on him. Bring me back the printout, and we'll figure it out. Well, it turns out that the Dingleberry that he took the guns from had a felony manslaughter conviction from the mid-1960s. Well, and I told him, dude, he can't have these guns back. I don't care what you promised him. And you multiply that, every single one of these is a headache. So we're going to talk about some other ways that we deal with that. I told him, the thing you need to do, go have a little discussion with the magistrate and see if he'll give you, even if the DA throws us out, at least this turkey's not getting that gun back. We're at least going to deal with this one here out of 1,000 of the darn things that we've got here. Because otherwise, this clown would come back a week later and he'd be inquiring about his gun. And guess what? I'm the ogre who's going to tell him no. And I don't mind telling him no. The key statutes that we pay attention to, there's one is from 1511. There's another one in 14269 that governs how these statutes are, how firearms may be disposed of. And then there's also one in Chapter 50D. There's also the federal statute, which I'm going to show you. Let's see. This is the federal statute. I got this data right off of the ATF's webpage. These things are, starting off here at the very top, some of the complications that we found. Say, under indictment or information in any court for a crime punishable by imprisonment for a term exceeding 1 year, which generally is going to mean typically a felony. We did some research actually in the past week or so. Generally, if somebody's under indictment, of course, their case has been transported into superior court. So that's even if they're just under indictment, then at the very least this is at least a temporary bar from being able to transfer firearms to that person. And then there's a little blurb here about an information. Well, it turns out information is basically if a DA does some sort of a written accusation that against the person that is presented basically to the superior court that is not an indictment. That's the definition of the North Carolina law of an information. But if they're under either one of those, then sorry, can't have it back at this particular time. And of course, if they're convicted, then that's a more permanent law. Which then brings us to the second one, which is the convicted of a crime punishable by imprisonment for over a year. Okay, so those two. The first two are not that difficult to research. The fugitive from justice, generally that means, because you're dealing with federal statute, that means that it's going to be somebody that is fugitive and there's reason to believe that it's across a state line, and we don't know where they are. How do we not get that? Now it gets interesting here when you have an unlawful user of or addicted to any controlled substance. We had this clown who he called me up on a Friday afternoon and wanted his hunting rifle back. well, this hunting horse, I need to research this. Well, I want my hunting rifle, I can go hunting this weekend. Okay, this is in June. Not much. I come to find out that this turkey here, the gun was, okay, he was the victim of a larceny of a firearm, and his brother had allegedly stolen the thing, had pawned it, and the brother had a conviction for obtaining by false pretense of this. The case was disposed of, but then when I researched the victim, found out that he had been picked up for a probation violation in court, and he had, when they searched him, they found he had a whole bunch of little pack of empty plastic baggies and he admitted to the deputy, oh yeah, those contain heroin, I forgot to throw them away before I came. So, all right, you got that kind of thing on you. I am under a presumption that you are a drug addict. And I found there were several more, that this is not just a one-time event in March. He had another thing from like earlier in the year, and then he had another minor drug violation. Obviously, the man is a doper. Well, I went and had a little discussion with the DA, who agreed that there's going to need to be a hearing, which is provided for in state law. To make a long story short, they had a hearing before Judge Stevens himself, who is the Chief Resident Superior Court Judge. Judge Stevens listened to all, to the state, listened to this guy and said, oh, I want my gun back. The judge decided, ruled that man is apparently not a drug addict and he can have his gun back. All right. I'm not going to argue with the judge under that circumstance. All right, fine. So my staff had to do his gun back. And that was that. And then a week later, he got picked up for drugs again. Right? In the meantime, hopefully he got rid of the gun behind so what I think he's going to do with it anyway. So these are anything but simple. Has been adjudicated as a mental defective or has been committed to any mental institution. So this actually there's two parts here that are of interest. The first one, adjudicated as a mental defective, that's actually not that easy to find out if somebody, where the judge is actually adjudicated in this way. If you can find it, well, then you're, at least you got a way of keeping this guy from getting his gun back. We had a case early last week where we found out about a gentleman. He confirmed he had been committed over for like 2 nights in Holly Hill, which is a mental institution, recognized as a mental institution in my county. So by the fact that he had been committed there, and my department's legal advisor advised he is a prohibited person. He is going to need to get a court order. So I called him up and gave him the bad news. So and I can tell you that these judges with all these mental subjects that are getting a hold of guns and they're doing stuff in Colorado, stuff that happened in Newtown, Connecticut, good luck getting a court order. So we're just going to sit on that man's gun collection for a while. So illegal alien, that kind of self-explanatory, maybe perhaps not the easiest thing to find out, but you may just ask the guy. Or ask for his ID and present you with counterfeit ID documents. Well, you may be able to get a charge out of that. But it also shows you're a legal alien. You can't get it back. Discharged from the military under dishonorable conditions. Very, very hard to find that out. It's just not that easy. Now, maybe I'll ask the guy point blank, bring you're up, and I find out, just talking about, oh yeah, you were in the Corps. Need you to bring your discharge papers. Let me take a look at them. And then you never know what you may find. Has renounced his or her United States citizenship. This is also very hard to find out. You're going to have to, I did an experiment once. I did a Google search on this. And I wound up going to an IRS website, and there was like a list of people that had renounced their U.S. citizenship, ostensibly for tax purposes. But it only listed for that particular month, and so I could not find, at least on my initial go through, like a master list of who all has renounced their citizenship. So that's, you may have to ask them a question. Now, Subject to a court order restraining the person from harassing, stalking, or threatening an intimate partner or child intimate partner. I mean, you run a DCI check on them, and you should be able to find that if there is one that is in effect. If they're in effect, while it's in effect, too bad, can't happen. Now, I don't mind holding on to your guns until that's all done with, and then we'll see. But under Chapter 50D, before they can get those guns back, they're going to need a court order, and that's in the statute. Now, has been convicted of a misdemeanor crime of domestic violence. So I used to think that, you know what, if you got have a conviction under, you know, if that case smells like, you know, you threatened your ex-wife and you were convicted of communication of threats, you were going to do something bad to her. As far as I was concerned, that's a misdemeanor domestic violence conviction. That's a lifetime bar. Believe it or not. Now, there is a little more complicated than that, it turns out, because there is under the federal statute, yes, we have a misdemeanor, but it has to have an element which includes the use or attempted use of physical force or the threatened use of a deadly weapon committed by a current or former spouse, parent, or guardian of the victim. The usual things that are considered under North Carolina law to the person to be considered to be in a domestic type of arrangement.